once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो conclusion हुआ है full court का, in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete your thoughts?
Page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
Zahid, para 36 is very important.
Zahid Sahab, please argue kariye as you want to.
So para 37 का ये, I'm just reading.
Zahid Sahab, अगर मैं आपसे सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं तो आप कहें फिर सवाल ही नहीं बनता है. आप अपना आर्गुमेंट कर लें कंप्लीट, फिर हम आपसे सवाल पूछ लें.
I mean, I honestly feel that today, I mean, I'm trying to answer questions.
आप पहले आर्गुमेंट अपना कंप्लीट कर लें ना.
They help in this debate.
जी.
So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord.
A line of distinction.
A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of the Constitution as conferred upon it under Article 188 of the Constitution. That is what is being...
Ajay, can you now go back to 536 AA?
If this line of distinction is drawn, Mr. Zahid Ibrahim, if this line of distinction is drawn,
yes,
that which means that the rules made under 188 are of a different category altogether, then there's no need to say that those rules are at a higher pedestal. Then those rules and rules made which are normally called subordinate legislation fall into two different categories. It seems to me that the passage, that those words that you have just read out from page 536 on a higher pedestal is not vis-a-vis a category that the Supreme Court in the words that you have just read out,
my lord,
say fall into a totally separate and distinct category. And if this is correct, then the higher pedestal can surely be and not subordinate legislation or rule-making power which is of a totally different nature. Would that not be a proper reading of the judgment as a whole?
Perhaps like the first sentence of paragraph 37, in fact, perhaps answers what your lordship is saying. Supreme Court itself says, in view of the above discussed principles of interpretation, it seems immaterial to discuss whether the Supreme Court rules are subservient to Article 188 of the Constitution. That is an immaterial argument, where it draws a comparison and says that they are on a higher pedestal. That is only in relation to rules made under some other statute. That is the point. My lord,
if you go back to 536 AA, now if you are to read this line disjunctively, object whereof was to enhance the power of review as conferred upon Supreme Court under Article 188 of the Constitution, then if you go to read it like the petitioners want us to read it, that would mean that the Supreme Court is now bound by Article 188 either, because it's giving it more power than the Constitution itself. Surely that cannot be the case. So it has to be read in context to the line that you've read. I don't know.
I understand that, you know, we are all pressed for time. I don't want to sort of.
हम पढ़ लेंगे पूरा judgment.
Ji, my lord, the next point I want to make is in relation to the appeal.
But before you go to appeal,
Entry.
What do you say about entry 58 on which you rely upon? That entry 58 is, since it is not conferring legislative competence, the rules that you rely upon, rules of interpretation, the purpose of entry 58 is the negative aspect of those rules, to make sure that a competence given elsewhere other than the lists, that is totally outside the scope and power of provincial legislature. That's all that the purpose of 58 is. It does not confer legislative competence, and therefore the principles that you rely upon really don't apply. What would you say to that?
My lord, my response to that would be that.
ये जाहिद साहब बहुत अच्छा सवाल है. Shall we take the break now, and you have received a number of queries, just mull them over, and then you just be precise in your answers, because we will hear you, don't worry. So we can take a slightly longish, make it this lunch break as opposed to 1:30, and the prayer break or whatever you want to make it. Just make these questions are very valuable for food for thought. And then mull them over and respond to us.
I promise.
We will just come back in half an hour. Is that all right?
I promise to continue, but I can't promise to be able to have all the answers to the questions posed.
You've seen what's been happening these last few days.
Yes.
You should be ready for that.
I've tried, my lord.
आप लोग भी जरा repetition ना कीजिएगा, कोशिश कीजिएगा, नए बातें कीजिएगा जो इन्होंने नहीं की हैं. चलें.
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी है. चीफ जस्टिस के सवाल पर जवाब वकील आबिद जुबैरी ने दिया कि इससे फर्क नहीं पड़ेगा, और चीफ जस्टिस काजी फाइज ईसा ने रिमार्क्स दिए कि हम आज केस खत्म करना चाहते हैं. और न्यूज़ स्टूडियो से अब तक के लिए इतना ही.